Hello and welcome to Courts This Week by LiveLaw. I'm your host, Debojit Das, and as always, I'm joined by the brilliant advocate Ostika Das to help us break down all the biggest legal stories. This is your essential deep dive into the most significant legal developments, judgments, and everything else that happened across India's courts over the last 7 days. Ostika, we have to start with the most talked about story of the week. And it's not about an order from the court, it's about a complete lack of order in court.
That's absolutely right. Picture the scene, it's a packed Monday morning, the first day back after the Dussehra break, and courtroom 1 is buzzing. Then, out of nowhere, chaos. A 70-something-year-old advocate named Rakesh Kishore tried to hurl a shoe at the Chief Justice of India, B.R. Gavai.
That is just surreal. What was the motivation here?
It has since emerged that the advocate was reportedly upset over a recent remark made by the Chief Justice regarding the restoration of a Lord Vishnu idol at the Khajuraho temple complex.
So how did the Chief Justice of India react to this shocking act?
With remarkable calm, he simply turned to the next lawyer and said, "Don't get distracted. We are not distracted by this." Later, the Chief Justice of India also called it a forgotten chapter and said that him and his brother judge were shocked but had moved on.
But the bar wasn't so quick to forget.
Not at all. The reaction from the bar was immediate. The Supreme Court Bar Association expelled Kishore and the Bar Council of India has suspended his license. Senior politicians and parliamentarians, including the Prime Minister himself, have condemned the attack in very harsh words. Many also pointed out that this was an attack on more than just the Chief Justice of India. It was an attack on a Chief Justice who is the first Buddhist and the second Dalit to occupy that office. The Supreme Court itself has decided not to pursue legal action, but a Supreme Court lawyer has formally asked the Attorney General for consent to start criminal contempt proceedings against Kishore. The letter argues that his act was a deliberate attempt to scandalize this court and erode public trust.
Let's move on to some good news for in-service judicial officers. The Supreme Court has finally settled the law on who can apply for direct recruitment as a district judge.
Yeah, this is a major change that we are seeing. The Supreme Court ruled that a judicial officer who has a combined experience of 7 years as an advocate and as a judge can now apply to be directly appointed as a district judge.
Wait, why is that a big deal then?
Because under the earlier ruling, they were completely excluded. The court said that it was unfair that government prosecutors and pleaders who appear before these judges are eligible, but the judges themselves aren't. It was a violation of the right to equality and equal opportunity under Articles 14 and 16.
So what about the requirement in the Constitution that talks about only advocates with 7 years of practice?
That's a great question. The court clarified that the Constitution says a person not already in service with 7 years of practice can be considered, but this doesn't create an exclusive quota for advocates. They also made one crucial clarification. The 7 years of practice must be continuous. Anyone with breaks, even if the total adds up to 7 years, won't qualify. Now, all states and high courts have received 3 months to amend their recruitment rules.
The restoration of Jammu and Kashmir's statehood is back in the spotlight. So what's the latest in the Supreme Court?
If you remember, in 2023, the abrogation of Article 370 was upheld by the Supreme Court. So now, applications have been filed in that disposed of matter seeking the restoration of statehood of Jammu and Kashmir, which has now been turned into a union territory. The union government through SG Tushar Mehta told the Supreme Court this week that Jammu and Kashmir has seen peace and progress and successful elections since Article 370 was scrapped and it was turned into a union territory. However, the Solicitor General also cited continued security concerns, especially after the recent Pahalgam terror attack, and asked for 4 weeks to file a detailed response.
So what did the petitioners ask here?
So a few applicants, including an MLA and a teacher, have returned to court to ask for that promise to be kept of restoring statehood to Jammu and Kashmir. The petitioners argued that if security is the reason for the delay, the recent terror attack happened under central rule, so that argument doesn't really hold. They pointed out that tourism is booming, life is stabilized, and democracy can't just be put on hold indefinitely.
The integrity of any election depends on one thing, a clean voters list. But in Bihar, the Special Intensive Revision or SIR of electoral rolls has turned into a long-running controversy now before the Supreme Court.
We've spoken about the Bihar SIR before, but here's a quick recap. It's basically a special intensive revision, a massive voter list cleanup ordered by the Election Commission of India just months before the assembly elections. Petitioners, including the Association for Democratic Reforms and Yogendra Yadav, called the process arbitrary and opaque. They argue the exercise has turned into this kind of backdoor citizenship test with voters being asked to produce a long list of documents for inclusion, which could potentially disenfranchise lakhs of voters. The Election Commission of India, however, maintains that it's lawful and necessary to ensure only genuine citizens remain on the rolls.
So, what's the latest in the Bihar voters list case right now? Some news reports are claiming that a false affidavit was submitted.
So, there was quite a bit of back and forth in court this week. The ECI's lawyer accused the ADR, that's the lead petitioner, of filing a false affidavit concerning a person claimed to be wrongly deleted. The judges weren't pleased either, asking lawyers to be more careful when submitting documents. However, the biggest takeaway from this week was that the bench said let's focus on solutions and not accusations, and directed Bihar's Legal Services Authority to provide free legal aid to everyone left out of the voter list. Paralegal volunteers will now reach out, explain the right to appeal, and even help draft those appeals.
So the idea as of now is that no one loses their vote just because they cannot afford a lawyer, figure out the process, or even navigate the paperwork.
That's right.
Our next story is about something that affects every young person in the country and, as an extension, affects everyone. The court has said that sex education shouldn't start in class 9th. It needs to start much earlier.
Yeah. That's right. This came up while the court was hearing a bail plea by a 15-year-old boy accused under the POCSO Act. A bench of Justices Sanjay Kumar and Alok Aradhya had earlier asked the Uttar Pradesh government to explain how sex education is taught in the state. The state said it's part of the syllabus only from classes 9 to 12. The judges weren't satisfied and said that's too late and children should be informed from a younger age about puberty, consent, and the changes that they go through.
That's quite a progressive and powerful observation.
Absolutely. And it's rooted in something larger, prevention through awareness. Every year we are seeing rising POCSO cases, and a lot of the time the offenders are children themselves. The court's point is clear: early education is not about encouraging anything. It is about equipping children with knowledge so that they understand boundaries and the consequences of their actions.
So in short, the court's message was simple: start the conversation much earlier.
That's true.
The Supreme Court this week took up a really interesting question for reconsideration. That is, should under-trial prisoners be allowed to vote? The court has now issued notice to the Centre and the Election Commission on a public interest litigation filed by a woman named Sunita Sharma, represented by Advocate Prashant Bhushan.
What makes this case significant is that Section 62, subsection 5, says that anyone in prison, whether convicted or just awaiting trial, cannot vote. It's a complete ban. The only exception is for people held under preventive detention laws. And the petitioner in this case argues that this is unfair because it treats everyone in custody the same way, even those who haven't been found guilty of anything. Over 75% of India's jail population are under trials who still enjoy the presumption of innocence.
So, just to be clear, the petition isn't asking for a free pass to all prisoners.
Not at all. It actually suggests a practical framework, setting up polling booths inside prisons or allowing postal ballots for under trials. The petitioner points out that even countries like Pakistan allow under trials to vote. The case also challenges an old precedent, the Anukul Chandra Pradhan judgment from 1997. At that time, the court upheld the ban, saying that the right to vote was only statutory. But since then, in the Anup Baranwal case from 2023, you'll remember, the court recognized the right to vote as a constitutional right. So now, the question is whether that old logic still stands.
Let's switch gears to take a look at a case in the Delhi High Court that could be considered to be a win for free speech. What's happening with the Staff Selection Commission and the ban on discussing exam papers?
So, the SSC issued a notification warning that nobody, students, coaching institutes or YouTubers could discuss or analyze SSC question papers after the exams. They said people could face criminal action under the new anti-cheating law, the Public Examination Prevention of Unfair Means Act 2024.
So they're using an anti-cheating law to stop academic discussion.
Exactly. That's the problem. The law covers unfair practices during exams, not open discussions after they've ended. The petitioner is arguing that this is a massive overreach and violates the right to free speech. The Chief Justice in the Delhi High Court was openly skeptical, calling it a gag order, and asked the Centre and SSC to explain how this ban fits under the law. The big question is whether a law meant to curb cheating can really be used to silence public discussion after the exams are over.
From one end of the country to the other, we take a look at the financial aftermath of the Wayanad landslides that also claimed hundreds of lives. The Kerala High Court is right now dealing with the financial aspect of the disaster, specifically the demand for a complete waiver of bank loans owed by affected families, and the Kerala High Court has expressed its displeasure with the centre. What can you tell us about this, Ostika?
So this is a suo motu case the Kerala High Court took up after the massive Wayanad landslides in July 2024. The court has been tracking the relief efforts ever since. Right now, it's unhappy with the centre for saying it can't waive loans for affected families. The government told the court that loan waivers fall outside its powers and that banking decisions are governed by RBI rules. But the bench, led by Justice A.K. Jayashankaran Nambiar, wasn't convinced. It said this wasn't about lack of power, it was about a lack of will, and reminded the centre that the constitution doesn't let it hide behind bureaucratic excuses. The judges pointed out that if states like Assam and Gujarat got central aid for less severe disasters, Wayanad deserved at least the same compassion. Although it stopped short of directly ordering the centre to act, respecting the separation of powers, it did issue notices to major banks like Bank of Baroda and Canara Bank and state recovery proceedings against victims for now.
Thank you for tuning in to Courts This Week. We'll be back next weekend with more from the world of law.